1.5 minutes.
Yes, Your Honor. Thank you. May it please the Court, I am the attorney who commenced this action 18 years ago when it was a reasonably simple minority shareholder freeze-out case. And since 1989, when it was filed, as the Superior Court in this case found, we encountered an extraordinary series of proceedings. And I would dare say that this Court has rarely, if ever, seen the number, type, or duration of contemptuous actions by a member of the bar as took place in this case. Judgment entered in 1991, and in the post-judgment proceedings that have gone on for the past 16 years, over 500 docket entries have been made. We've been to the appeals court twice. And Mr. Ottenberg and I have been sued in 4 or 5 other jurisdictions for our efforts to try to collect this judgment. We're now here 18 years later to consider the authority that a Superior Court judge has to default a party who regularly and blatantly violates court orders and remains a fugitive and in contempt of court at the time the court is considering that party's request for relief. The appeals court in this case said that Mr. Manga and the executrix of his estate had the right to be heard concerning the IRA accounts that are at issue in the case. In ruling in that manner, we submit that the appeals court failed to truly appreciate the scope of the contemptuous acts that the Superior Court had experienced over the 5 or 6 years at that time after the judgment entered. The appeals court focused on Mr. Manga's refusal to turn the IRA accounts over to the receiver as the contemptuous act that was at issue. But that was not the sole or even the most important predicate for the Superior Court's decision. At the time that Judge Fabricant ruled on the entitlement to the IRA accounts, Mr. Manga was still in violation of the court order compelling discovery, was still in violation in multiple instances of the injunction that prohibited him from transferring assets out of Massachusetts. Indeed, the evidence was that hundreds of thousands of dollars had been transferred out of Massachusetts in violation of the injunction. There was still a capias outstanding for his arrest at the time Judge Fabricant considered his claim to those IRA accounts. He was a fugitive, refusing to respond or appear for the capias, refusing to comply with any orders of the court. When the receivership order entered in 1992, Mr. Manga was ordered to turn over books and records concerning his assets and those of his companies, and was ordered to turn over his assets and the assets of the companies to the receiver. There's no dispute that at no time did he ever turn over a single piece of paper to the receiver and never turned over a single asset to the receiver. In fact, Mr. Manga fought the receiver at each stage of the receiver's efforts to collect that judgment, bringing cases in Florida, Maryland, New York, and Massachusetts federal court, all in an effort to impede the receiver from performing the order that had entered by the Superior Court. This was not a single act of contempt that was viewed by Judge Fabricant as the basis for finding a loss of those IRA accounts. It was a series of actions, again by a member of the bar, over a 5 or 6 year period that had rendered him entirely judgment-proof, except for those IRA accounts. So I think the fundamental error in the appeals court's decision here is looking at this as a single act of the failure to turn over those IRA accounts to the receiver. The decision of the Superior Court was based upon a whole number of dozens and dozens of violations of the court orders. The other thing that's interesting about the appeals court decision in this case is the court distinguishes between the loss of the right of an appeal and the loss of the right at trial, and found that while you may lose your right to appeal from misconduct, you can't lose your right to a trial. And that is certainly contrary to many of the prior decisions of this court, which have found a litigant by its own misconduct to have lost its right to a trial. We have the Rockdale management case in which this court found that a fraud perpetrated on the Superior Court warranted the entry of judgment against a party in that case. In the Roxy Home case, a party failed to comply with a discovery order, was ordered to convey property, a fundamental constitutional right that was lost because that party engaged in misconduct. So I think that there's a fundamental, thank you, Your Honor, legal error that was made by the appeals court here, and I will now turn it over to Mr. Ottenberg. Thank you.
Thank you.
May it please the Court, I'm John Ottenberg. I'm the individual who had the misfortune to be appointed receiver in this situation some 16 years ago. What this case, I think, is the important...
What's the value of these accounts roughly right now? Do you know?
The IRA accounts?
Yeah.
$92,000 was turned over to me as receiver and dispersed. This money has all been distributed. There was also approximately another $92,000 which was paid to the funds as payment of their legal fees under indemnification provisions under the IRA agreements. Those $92,000 that was paid to the funds would have been additional assets which would have come into the receivership. But those funds were lost because of the defiance and willful behavior of Mr. Manga and Ms. Maharaj in refusing to turn over those assets. It was a result of the litigation in multiple jurisdictions, the protracted litigation in Massachusetts. Please keep in mind that in July of 1992, there was a very specific order directed to Mr. Manga and Ms. Maharaj to turn over those funds. They never, ever complied with that order, and as well, of course, continually defied a whole series of orders. What this case is about, and I think it would send out a terrible message if the Appeals Court 2 decision was left in place, what this court is about is the respect due to a superior court, an order of a superior court judge. As the Appeals Court said in Appeals Court 1, the significant issue is whether the appellant willfully violated the trial court's orders, thereby replacing recovery of the judgment in serious jeopardy. That's the same thing that happened and is applicable in Appeals Court 2. $92,000 of those IRA funds were ultimately lost. And that doesn't count the amount of money that I had to spend and was paid to me to litigate the issues relating to those funds.
Did you ever present any evidence that these IRAs were not exempt?
Yes. First of all, there was a financial statement of Mr. Manga that was prepared, I believe, in 1990 or 91 that is part of the record in this case that indicated he had no IRA accounts. I would also say that the Appeals Court has claimed that I conceded somehow that these accounts were exempt. They were not exempt. Under the applicable statute in 1992, in July of 1992, which was the then current version of Chapter 235, Section 34A, the only accounts that were exempt were ERISA-protected accounts. These were not ERISA-protected accounts. There is a Superior Court decision, the Sommer Bank case, a 1991 decision, which is part of the record appendix at I believe it's at page 222 of the funds record appendix. There are 3 separate record appendix, which expressly held that IRA accounts, which were not ERISA-protected accounts, were not exempt at that time. So there was both factual evidence that Mr. Manga did not have an IRA, evidence upon which I relied in going forward. There was also evidence that there had been a concerted course of conduct to move assets from one name to another name, to shield it in various ways. The real estate, there were mortgages placed on the real estate. There was a homestead exemption placed on the real estate. There were funds flying around the world in all different names, but the statements were coming back to Ms. Maharaj and Mr. Manga. There were accounts in Mr. Manga and Ms. Maharaj's name in other jurisdictions that had been moved from Massachusetts. So there were all a variety of bases which led me to believe that these accounts, number one, weren't valid. And number two, the law at that time was that unless they were ERISA-protected accounts, they were not exempt from the claims of creditors in any event. And as the Court knows, statutes, unless they expressly state that they have a retroactive effect, are not retroactive. And 235, Section 34, which has changed since the date of the applicable time, did not provide for any retroactive effect. I want to also suggest to the Court that in certain respects, from a practical point of view and a mootness point of view, this case should not continue. Not only has it been going on for 18 years, but if there's no funds in the receivership, there's no money to finance the receivership collecting assets. Mr. Sommer has died. He was one of the recipients of these funds. Brooks and Lupin, which was another recipient, that LLP no longer exists. I mean, we'd really have to sort of try to put Humpty Dumpty back together again if this case went back for further proceedings. I apologize. Thank you very much.
So let me just ask you one question. Was the receiver appointed because the corporations were essentially without assets, or was the receiver appointed as sort of a Rule 37 mechanism to sanction, as a form of sanction for failure to comply with discovery?
I think really neither, Your Honor. I think the receiver was appointed to try to preserve and collect together a corpus of assets to allow this judgment to be satisfied. That was the primary purpose. When I became involved, Mr. Manga, who was running these businesses, these were essentially service businesses, much like a law firm. He was of parts unknown. He wasn't participating, and therefore the businesses could not continue. I made a determination and presented it to the Court. But I was not appointed essentially for anything other than to try to collect together assets, preserve them in Massachusetts, make sure that there was something to satisfy this judgment. At least that's my view of why I was appointed. Thank you very much.
Mr. Barniak.
Good morning, Your Honors. May it please the Court, my name is John Baraniak on behalf of the fund appellees, and sitting with me is Kristen Moody from Holland & Knight, also on behalf of the fund appellees. The fund appellees stand in a little bit different position than Mr. Ottenberg or Mr. Summers, in the sense that the appeals court affirmed the summary judgment dismissal as to the fund appellees. And no one has sought further appellate review of that part of the appeals court's decision. The fund appellees were dismissed out because they were mere stakeholders in this case. They were caught in the crossfire between Mr. Manga on one hand and Mr. Summers and Mr. Ottenberg on the other. To the extent that in 1996, they filed a motion or a claim for interpleader, which claim was never answered by Mr. Manga. And then they froze the funds at the court's order. Mr. Manga, in defiance of the Superior Court's order, initiated and continued to prosecute claims against the funds in Pennsylvania. The Pennsylvania courts issued an order ordering the funds to turn over the IRA accounts to the Pennsylvania court. So the funds became stuck in a situation where they were subject to conflicting court orders, one from the Pennsylvania court that said give the money over here, another from the Massachusetts court which said hold on to the money and keep it here. Hence the reason for the interpleader, and ultimately Judge Fabricant deciding that she had had enough of Mr. Manga and his disregard for her orders, entered summary judgment and ordered the funds to turn the money over to the receiver, which the funds did. There is, if you read the appeals court decision, there are several reasons why the appeals court could do that. I think the most compelling is that the funds should not be in the case because they were just complying with a facially valid court order. And I cite two cases, one from Massachusetts, the Phelps case, which is an older case from 1873, which says a party can't be subject to liability or they're insulated from liability if they do comply with a court order. And there's a more recent case, which, although from outside the district, the Hubner versus Alliance Fund case from the district, Federal District Court in New Jersey, which is a 1999 case, which is almost identical facts as the one here. Again, it holds that a stakeholder cannot be subject to liability merely by complying with a court order to either hold funds or turn funds over. I think another possible alternative grounds for affirming the appeals court decision is Mass Rule Civil Procedure 41B2. I know the appeals court rejected that and said that it didn't apply here because Mr. Monga was a defendant and not a plaintiff. If you look at the totality of the circumstances, in this particular case, he was a defendant, but he was also a plaintiff in the Pennsylvania cases, which the Massachusetts court had told him to start prosecuting. So he was acting as if he was a plaintiff. And so I think that provides an alternative mechanism for dismissing his claims, at least against the fund appellees, for failure to comply with the court's orders. And I don't think it's a too drastic sanction, given that the Globe newspaper case, which I cite in my brief, which basically dismissed a plaintiff's claims for failure to strike an addendum clause in the complaint. The conduct here, as both Mr. Brooks and Mr. Ottenberg have cataloged, was much more egregious. Repeated contempts. The court really had resorted to fining Mr. Monga. Didn't seem to work. Issuing a caveus for Mr. Monga's arrest didn't seem to work. Really, the court was at loose ends. And at the end of the day, this is the remedy was proportionate to the behavior, I think.
Thank you. Mr. Flynn?
It's Flynn. Good morning, Your Honor. May it please the Court. There are so many misstatements in the three presentations which have been made. I just would not have the time to go through them if I had an hour. I will only address a few points. And I'll begin because it's hard to reconstruct this case in a way that is simple, though I believe it is, in fact, a simple case. I'll begin with Mr. Baraniak and his statement referring to the lawsuit in Pennsylvania and the fact that there was...
Let's start at the beginning, though. Did your client ever comply with the 1992 order to turn over all assets?
Absolutely.
And what did he turn over?
They were seized. That is...
Excuse me? I'm sorry. What did he turn over?
The receivership occurred, Your Honor. And immediately what you had was Gestapo-like seizures of all of the assets, including all of the documents in all of the companies, including all of the documents in the Monga home. This was done while he was out of the state.
Out of the state? He fled the state. He never came back. There's a capias issued for his arrest.
Your Honor, it's a very simple matter. If, in fact, he was in contempt, why is it that these attorneys filed repeated motions for contempt and withdrew them? That is, if, in fact, we're talking about a contempt order that was issued in the late 80s and no further order was relevant, why did they bother to file all these other contempt motions?
Well, maybe because it was a useless effort. It was a fool's errand. Didn't Mr. Monga move a lot of the assets, or at least most of his assets, out of the state by the time the Superior Court, or after the Superior Court entered the order?
There is no evidence whatsoever of anything other than allegations. There was an affidavit which was prepared by Ms. Brooks, which is the foundation for all of the other claims. There was never a shred of evidence that is in the hearing in the appeals court. The court, I think it was Justice Graham, asked Mr. Baraniak, I think it was Mr. Baraniak, a direct question, is there any evidence of fraud here?
Well, we're not talking about fraud. We're talking about moving assets out of Massachusetts after the Superior Court judge ordered him to turn them over.
I would consider that to be fraud. That's what I mean by fraud. There is not the slightest shred of evidence. There is no evidence whatsoever. There is
So you're saying there's no evidence in this record
in this record.
that indicates or that supports the fact that Mr. Manga moved assets out of Massachusetts after the Superior Court judge entered her order that he turn them over?
To the best of my knowledge, that's exactly right, Your Honor. What we have are allegations in which everything that ever occurred was listed in a laundry list, putting the most sinister spin on it that you could possibly imagine. What is it that was happening at the point when the receivership was imposed? The question you pose is exactly the right one.
No. Before the receivership was imposed, it was when the Superior Court judge entered her order that he turn over the assets.
I may be missing something about the chronology here, Your Honor.
Wasn't the receiver appointed in response to claims that Mr. Manga moved assets out of Massachusetts after the Superior Court judge ordered that he turn them over?
No, I think the claim, as I understand it, Your Honor, is that somehow Mr. Manga was doing his best to get rid of his assets in order to avoid having to pay the judgment, which is totally false. That is, what he expected was to win the appeal. He was pushing it.
That really isn't my question. Was there a claim that he moved assets out of Massachusetts after the Superior Court judge ordered that he turn them over?
You're focusing on a piece of the record, Your Honor.
I just want an answer to the question.
Yeah, and I'm trying to answer it. I'm simply saying that if you're referring to a specific point in time.
That's exactly what I'm referring to.
I can't answer that other than to say, to the best of my knowledge, nothing like that ever happened. That is, the only order that I'm aware of where he was found in contempt had to do with discovery. Never was there an order.
I'm not talking about whether he was found in contempt. Was there a claim that he moved money out of Massachusetts after the Superior Court judge ordered that he turn the funds over?
At some point there was such a claim. That's perfectly clear.
Okay.
Was that claim supported? No. That is, it was supported in the sense that anybody can say anything. We now have all the records. We can see what happened. We're talking about a business in which transactions will, in fact, be.
But you're saying it wasn't supported because the judge didn't believe Mr. Manga's view of the facts. If you believe somebody else's view of the facts, it was supported.
Your Honor, he's entitled to his day in court. What we have here is a seizure of a company worth $1.5 million sold for pennies on the dollar. That's the asset he had to pay the judgment. The receivership was imposed. The law is perfectly clear. You're supposed to preserve the assets. At the time when he seized the company, Mr. Ottenberg filed a report which belies what he says today. The company was healthy. The reason he gave for saying we need to sell the companies was not because they're unhealthy, because Mr. Manga is out of the state doing other things, because he's busy transferring the assets. The assets he had was the companies. That's what he would have been transferring. That was not transferred. It was seized. It was sold for pennies on the dollar.
Well, let me ask you this now. The receivership order, I'm trying to sort of piece together the record here, and it is somewhat complicated. But in 1991, he was enjoined from transferring any assets, and at least there is significant evidence that there were a lot of transfers made after that. Then the receiver was appointed in July of 1992. Your client appealed the receivership, correct? Did he appeal the order appointing the receiver?
I think he appealed everything that I think. I don't recall specifically, Your Honor.
And then he defaulted.
No, he did not default.
Well, then why did the capias issue for his arrest?
Why did the court not find him in contempt? That is, we're talking about a judgment that was entered 2 years after he died?
No, let's go way back to the beginning, because this really starts at the beginning. It starts at the beginning of his contemptuous conduct throughout these proceedings. He left the jurisdiction, a capias was issued. His appeal was basically, as I remember, the appeals court in the receivership appeal said, unless he purges himself, we're not going to decide this on the merits.
Your Honor, I beg you just let me say a few words about what I think the issue is.
Okay.
Okay. I just beg you, because I have virtually no time left.
All right.
Okay. We're talking about an order that 2 years after his death claims on a new theory that he forfeited his claim that the assets were exempt. Mr. Baraniak and the funds were the first to fight against Mr. Ottenberg as to their right to have access to these IRAs. They said, you're not entitled to it. We're not talking about new law that's been made since 1990. That's nonsense. The funds were very clear. All of their lawyers said, show us proof of fraud. And Mr. Ottenberg said, I'll show you proof of fraud. It's very strange. This man is young and he has $50,000 in his IRAs. Well, how many millions of Americans have funds in their IRAs which are supposed to be beyond the reach of creditors on any claim? The Guidry decision 1990 involved a union official who was found to have stolen money from the union. A constructive trust was imposed on his ERISA funds. The Supreme Court said no exception means no exception. Why? Because these pension funds are intended not just for the person, but also for that person's family. They're innocent. He may have been corrupt, but his family didn't participate in that. That's the issue here. We're talking about pension funds. There were ERISA funds which were seized, also ERISA funds, squarely. The claim now is that somehow IRAs weren't protected. There's nothing whatsoever in the Rossi decision of the Supreme Court in 2005 suggesting that there's been any change in the law. This is simply the fourth case. It begins with Mackey in 88, Guidry in 90, Patterson in 92, which says we said no exception. We mean no exception. And what we have here is a scheme which arises. It begins with a judgment creditor who's the judgment debtor never gets an appeal. I will mention parenthetically that the norms of what it means for a party to be entitled to due process, not to have their property taken away from them without due process, mean something which has been evolving. As it currently stands, since I'm applying to become a member of the bar in Paris, I can tell you that the European Court has, over the last 20 years, rendered at least 15 judgments against nations all over Europe because those nations denied someone the right to have the merits of their claim heard on the ground that that person was absent. There is a conflict. Yes, if you have a capias against, I don't know what. I never met Mr. Munger. I appear on the scene much later than that, okay? But I know that he was a very successful and wealthy man. He was succeeding in every way until a minority shareholder decides.
But there was a judgment. There was a judgment against him. Did he appeal the judgment?
Yes, he did.
And did he win or lose?
He never got a chance to have a hearing on that appeal. He was denied that hearing. And when he appealed, he tried to purge his contempt. There are references to the contempt. There's one contempt order against him.
Well, the appeals court gave him 60 days to put up the money so that he could reinstate his right to appeal. He didn't do that.
I don't think that was the issue at all, Your Honor.
Didn't they give him a period of time to...
No. We're talking about...
It was the last sentence of the decision.
My recollection, unless I totally misread the record, Your Honor, is that it has nothing whatsoever to do with his posting money. It has to do with it. I'm thinking about the what's the group of lawyers here in Massachusetts? I'm bad on names. It's a decision this year having to do with their not having appointed a lawyer. And this court said, quite rightly, you got to have an order that's very specific, so you don't have to guess as to what the order says, and you have to have evidence, a second requirement, that this person really is willfully disobeying the order. There is not a single order that was ever directed at Munger to turn over the IRAs. It keeps being said. All three parties said it. All three parties talk about contempt. Contemptuous conduct throughout. There is never anything other than allegations. The possibility of having rulings on these allegations of contemptuous conduct were withdrawn voluntarily. There was not ever an order telling Munger, in so many words, turn over the IRAs.
All right, I may have misspoken. I take it the appeal that the appeals court said they wouldn't decide on the merits was the appeal from the judgment. Is that right? Not the receivership. It was the appeal from the judgment?
Correct.
And that's because he was,
And the
a
claim-
capious had issue and he'd failed to comply with the order to turn over
And
assets.
then he spends the rest of his life until he died. That is, he had an appeal pending, and it was pending for 2 years only because the transcript was not ready. Not because he didn't try to get an appeal. He appealed the denial in Superior Court of his attempts to purge the contempt. All you have to do is read the affidavits and everything that he did. He's not trying to hide anything. It's the opposite. I mean, it's an Alice in Wonderland world. I think I heard. I think it was Mr. Ottenberg, but it could be Mr. Brooks, who said this man fought by filing a lawsuit in Florida and in New York and in Pennsylvania and in Massachusetts. He fought in every way. Well, what are you supposed to do except have recourse to the courts if you have a disagreement about whether an order is valid or not? There's nothing. What? You're supposed to say, okay, it's all illegal, but you told me to do it, so that's the end of it? Obviously, he's got a right to have a decision based on the rule of law, not just on allegations. We need to go back to the fact that this case has been treated as an equity matter since the judgment, and that virtually everything that's ever happened here has been ex parte. We're not talking about proof of anything. And that this man, he went to Pennsylvania. Why? Because that's where the funds are located. It is really ironic that the injunction, which was what could be more illegal than the same court which issued these other orders against Mr. Munger, also issued the order enjoining him from pursuing judicial remedies in Pennsylvania. It's illegal. There was no right to do that. If that lawsuit had gone forward, we wouldn't be here.
Mr. Flynn, thank you. Thank you.
Thank you.
No, you can send in a letter, and post-argument letter telling us what you wanted to say in your 1 minute. Thank you.